Next, please, Your Lordship.
Yes,
This is second bail application. So earlier order, Your Lordship order is page 70. Your subsequent development is that, Lordship, while rejecting bail application, Your Lordship has considered the birth certificate, Lordship.
Hmm.
And now police has, Lordship, seized one high school certificate of the victim girl, wherein it is seen that she is major, Lordship. That I have enclosed. That birth certificate, that matriculation certificate, Your Lordship will find page 23. Police already seized this. Page 22 is the seizure list, Lordship. That page 22. Seizure list. And page 23 is the certificate, wherein her date of birth is shown as 17/4/2005. And in the birth certificate, which was produced by the informant, that relates to 17/4/2006. And that certificate was obtained subsequently, that Your Lordship will find page 21. It was issued on 23/5/2016, subsequently. Page 21, down middle portion, Lordship will find date of register 23/5/2016. And in my humble submission, Lordship, that matriculation certificate will prevail over birth certificate as per section 94 of Juvenile Justice Act. And further development is, Lordship will find page 25. Both the accused and the girl, Lordship, they got married. So that Your Lordship, page 25, under Special Marriage Act, Lordship.
recently.
22/4. Only
Okay,
the
we will see it. Let the screen copy of the record come. What is this? The case is pending now.
investigation.
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 Search it not submitted.
Search it not something. Only fact is that the informant was not agreeing to the relationship. Therefore, this whole case was lost. So young boy, he is also 24 years.
Okay, we'll see if the age of the victim girl is above 18 years. Then.
His matriculation certificate, the police already seized that seizure list I have enclosed. So considering only protection, so
What is the case, Eddie?
some protection.
No. This
They
is
already
second
got
abuse.
married, Lordship. If police had-
That part, we have to issue notice to the informant also nowadays.
That is
It
right.
is POXO is also given.
But apparently it is a seized major, Lordship, from that seized document, from the documents which police has seized.
Okay, let the city come.
Notice, Lordship.
Yes, notice will go. You take a step today itself if possible.
Lordship.
Hand it over to additional people
Lordship.
or to his office.
Lordship. I have
Uh,
to take a step for register, through registry of the school. Routed through the registry. Registry will provide them. Lordship.
Is it the practice?
Yes.
But somebody used to hand it over in the office.
If
of the
to
head
sometimes
office also.
directly hand it over, sometimes they say we have not received. So
Received it,
therefore,
that's a-
it is
Acha.
routed through the registry.
Acha, okay. Heard Mr. Yamir, learned counsel for the applicant, and Mr. D.S. Doctor, learned additional people for the state respondent. Apprehending arresting connection with Supervisor PS case number 3150/2023 under section 342, 376, 323, 427, 506, IPC, Schedule section 6 of the POXO Act. This application under section 438, service is referred by applicant Umesh Bosumotari for grant of POS. Mr. Ahmed, learned counsel for the applicant submits that this is the second anticipated bail application. And the first one being, where is the order?
Page 17.
AB number 20 of 2024 was dismissed by this court on 17, by order dated 17/2/2024. Further, Mr. Ahmed, referring to annexure 5 of
4
the
and 5.
application at page number 23 submits that during the course of investigation, the IO has seized on birth certificate of the victim girl, school certificate of the victim girl, who is shows that her date of birth was 17/4/2020 on 25, And as such, she is a major, and the case has been lost by the informant as he is not agreeable to the relation of the victim guard with the present applicant. And therefore, Mr. Ahmed contended to allow this petition. Having heard the submission of learned advocates of both sides, it is provided that the learned additional PT shall produce the case hearing before this court on vacation or so India.
17 July.
17. In the meantime, the learned counsel for the applicant shall take step upon the respondent number 2. In view of the practice direction laid in the notification number 15.
It's 17 of 2020.
17 of dated
15 March.
15 March 2024.
Yes.
Through the office of the public prosecutor, Guwahati High Court, and also through the registry and public prosecutor of the Guwahati High Court.
Problem.
And number 2.
May please, Lordship.
Yes,
438 bail application Lordship. FIR Lordship will find page 16, my lord. 16, my lord. Here the petitioner is the my lord, caretaker, my lord, of the under the my lord, original owner, my lord. And in the earlier occasions, this honorable court allowed the my lord pre-arrest bail applications to the purchasers. That lordship will find page 39. Page 39, this honorable court allowed the pre-arrest bail applications to the purchasers of the land. I am only the caretaker of that land. So I have no any connections with regard to the allegations.
Rejected. Rejected. I got rejected. No, reject not. Yes.
allegation is against one Onima
Yes.
Hazarika.
Yes.
Onima Sarkar.
Yes, Onima sir.
Onima Sarkar.
I will, my lord, cooperate with the investigations, my lord. Lordship, the city, my lord.
You were the caretaker of the
Of the land, my lord.
Same
Earlier,
of the
my lord.
land.
Now, my lord, I am not the caretaker. Since my lord, June 2022, I have left that, my lord, land. At present, I am not the caretaker.
So why you were apprehending it?
Because, my lord, the police just repeatedly, my lord, asked me to appear before the, my lord, police. I have made statement, my lord, para 11, page 9.
Yes, local.
Para 11, page 9.
I leave it to us.
I will appear before the IO, my lord.
Heard Mr. R. Sharma, learned counsel for the applicant, and Mr. P.S. Locker, learned additional paper for the estate respondent. Apprehending arrest in connection with Bawagor PS case number 26 of 2024 under section 120B 420-406 468 IPC. This application under section 438 services referred by applicant Satinder Nath Roy for grant of years rate. To be noted here that above noted case has been registered under the siege of one FIR caused by one Vishnu Priya Hazarika on 19 29/1/2024. The essence of allegation, as reflected in the aforementioned FIR, is that the informant is the owner of a plot of land which she had purchased by deed number 935 of 1993, dated 25/2/1993. But when Onima Sarkar, wife of Devin Sarkar, had fraudulently prepared a power of attorney on 19/11/2019 and showing another woman in her place, sold the said land to another person. Mr. Sharma, learned counsel for the applicant, submits that the applicant is innocent and no way involved with the offense alleged in the FIR, and that he was earlier caretaker of the said plot of land, but now he is no longer caretaker of the said plot of land, and that he is ready to cooperate with the investigating agency. And this court by order dated 29/4/2024 in AB number 805 of 2024 has already granted the privilege of rehearsal to one Anjan Das and another and one Anjan Das and one Pradeep Kolita. And that the applicant is ready to cooperate with the investigating agency. Therefore, it is contented to allow the petition. Whereas Mr. B.S. Locker, learned additional PP submits that the case hearing may be called for. Having heard the submission of the learned advocates of both sides, perusal of the case hearing is found to be necessary, and accordingly it is provided that the learned additional PP shall produce the case hearing before this court on Locker when
Full family. After immediately after vacation also.
oh, Bobby?
Yes.
Oh. 17 July. In the interim, considering the submission of learned advocates of both the parties, and also considering the nature and gravity of the offense and the punishment prescribed for the same, and also considering the fact that two of the accused persons have already been granted the privilege of respect. This court is inclined to extend the privilege of respect to the present applicant also. And accordingly, it is provided that in the event of arrest of the applicant in connection with Moagar case number so and so, he shall be released on interim period bail on his executing upon the rupees 50,000 with one surety of like amount to the satisfaction of the arresting authority. Therefore, privilege is however subject to the following three conditions. Last condition, he shall not leave the jurisdiction of CJM Kamrupam without prior permission.
Query number 3,
Public.
permission.
Lordship, I am not feeling so well today, Lordship. Can we do it after vacation, Lordship? We shall be highly obliged. Lordship.
So on
Applicant
the
counsel-
other day, you have pointed out something
Lordship, I have pointed out regarding explanation number 4.
of
It says-
section 500.
Yes, Lordship, which says that if it is to be defamation, then my esteem
So do
in
do
front
you
of
have any decided case on that point?
that I will produce, Lordship. Even our own High Court has given judgment on those things. So
That,
those research I want to make, Lordship.
Whatever is stated in the written statement, it not amounts to.
That judgment I have given, that Kerala High Court says that it is a written statement, it is a judicial proceeding. So in case of judicial proceeding, it will not do. But it is a judgment of the Kerala High Court.
Hmm.
I could not find a judgment of that sort by the Honorable Supreme Court. But our own High Court has said, Lordship, that defamation will only happen if the esteem of the person concerned has been lowered in the eyes of the society and others. So here, if it is a judicial proceeding, here the esteem has not been lowered in the eyes of the others. There is no such evidence at all that their esteem has been lowered. I don't want to do the hearing. I have taken permission from my brother that since I'm not feeling well, so I want to do it immediately after vacation. And my friend is also not there, Mr. Gyasuddin is also not there.
Okay, on the pair being made by Mr. A. Bhattacharya, learned counsel for the petitioner. And having not been objected by learned counsel for the respondent, Mr. Recessal is the matter on.
Sir, 18th of July, any date, Lordship?
On 19 July.
19th July. Interim may kindly continue, Lordship.
Till then, interim order passed and is continue.
Deployed.
Item number 8,
Lordship, my senior is on legs in court number 13, Lordship. That matter is still going on. Lordship, this matter may be fixed after vacation, Lordship.
Why?
Lordship, now he is on legs.
Why
Lordship.
after vacation? Yes, no objection.
16 Lordship. 16 or
16.
17 Lordship.
Ms. So-and-so, learned counsel appearing on behalf of Mr. S.C. Kayal, learned standing counsel for the NCD. Comma, with consent from the other side, press listing the matter on 17. Here is a legal. Recessal is the matter on 17. Next,
item number 4, bail hearing.
Highly obliged.
CD receipt.
but who is the applicant?
Item number 4,
Whether on last occasion appear on
Panikor. We have the number, Kobe. Ever জানাই দিয়া? Next,
item number 5,
May it please your lordship. For 30-year application, your lordship. The allegation in the affair was that alleging that the petitioners who were the brother-in-laws to each other has committed rape on the victim.
is there a
at the
receipt blocker?
receipt receipt.
Your lordship, I would like to only point out one thing, your lordship. I insisted for seizure of the CCTV footage which had been installed in my shop to reveal the actual fact. So accordingly, I filed a writ petition, your lordship, annexure 5. Your lordship may kindly see annexure 5 page, relevant page 33, page 30. Your lordship, we start from page 31. And 32, paragraph 3, the learned counsel for the petitioner submit that because
No,
of some.
that day you have pointed it out.
Yes, and I have been, your lordship, accordingly, I have been directed to appear before the IO on 29/6, that is day after tomorrow, your lordship. And in pursuant to this order, your lordship, the police has seized the CCTV footage and pen drive, your lordship. Now, your lordship, I am praying that accordingly as per this order, I will appear before the IO. Suppose, and your lordship may be pleased to grant me some protection, and the police may be directed to view the CCTV footage. It will reveal the actual
No,
fact.
no. The thing is that how the police will conduct investigation, this court cannot direct.
No, in person to the
That
order
is
passed in
not
the
within the
repetition,
purview of this court.
your lordship,
What to
that is
do, what
heightened
not
your.
to do during investigation, because this is an anticipatory bail application. We
Yes.
are not monitoring the investigation of the case.
Your lordship, only, that's why, your lordship, I approached a read court. And the read court directed to seize the CCTV footage and the pen drive and directed me to appear before the IO. In pursuant to this order, CCTV footage pen drive have been seized. That is annexure 6 and 7, your lordship. My only remainder for your lordship, that will reveal the actual fact. Whatever other investigation, police has liberty to conduct, your lordship. At the same time, they should also view the CCTV footage. It will help the investigation.
This court cannot issue direction to the police.
So then, your lordship, I will appear on 29
with some your lordship may please to grant some protection, your lordship. I will.
Subject to the materials available in.
Yes,
the
yes,
case.
yes, that can be done, yes.
Yes, what material are there?
See, her 160 word statement has been recorded, and she has specifically implicated these two persons lordship. They have raped her lordship, and the witnesses lordship. There are some witnesses has been on the statement has been recorded lordship, where the witnesses has come out after hearing her hue and cry from their nearby houses lordship, and they have they are the witnesses therein lordship, and thereafter lordship the first they have submitted one CD drive which is empty. Thereafter, they have submitted one pen drive and hard disk lordship that has been sent for FSL lordship. That report has not been received, and the FSL report has received regarding the clause. The hard clause has been sent for FSL, and that is positive lordship. Hard clause were sent for FSL earlier lordship. The victim's clause. Clause were sent for FSL, and that is the positive marks regarding that. That is their lordship. FSL is their lordship.
How,
So,
how
lordship-
can, how can they compare it without taking this from the petitioner, your lordship?
Hmm.
How can they
So,
actually
lordship,
compare? Who's,
that will come lordship during
Who
the
did
course
it?
of investigation. Investigation is not completed yet lordship, and
You are on interim.
Lordship.
You are on interim.
Yes, Lordship.
You appeared before the IO.
Appear, Lordship.
Statement recorded.
lordship. Statement is not recorded lordship, but lordship, I have not found any material against him in the city.
No material.
Actually, whatever in this land gave me this money laundering cases lordship.
Mm.
If one case is found any another, everyone comes.
Mm.
One laundering case.
Heard Mr. RL, what is your name?
RL Sutia.
RL Sutia, Learned Counsel, appearing on behalf of Mr. A. Fanikor, Learned Counsel for the applicant. And Mr. P. S. Loco, Learned Additional PP for the state respondent. This application under section 438 certificates prepared by applicant. Omar Zuki Dekka, who has been apprehended, arrested in connection with Rokwakana PS case number 15 of 2024 under section 120B, T84, T92, T87, 406, 506 IPC, related section 7C, within bracket 2 of the Assam Money Lenders Act, Money Lenders Amendment Act 1968. For grant of years paid. Is to be noted here that above noted case has been registered on the basis of one FIR lodged by one. What is the FIR?
Apparent page 10 lordship.
The basis of one FIR lodged by one BB Khun Mili on 19 to 2024. The essence of the allegation made in the aforementioned FIR is that the informant had taken a sum of rupees 1,50,000 as loan at the rate of interest 6.67% per annum from on Rajiv Ghosh on 12/12/2023, and he used to pay interest amount of the money in case, but sometimes he could not make payment of the interest, and then Rajiv Ghosh and his manager Tuleswar Dotto alias Ramji had forcibly taken away his ATM card of Punjab National Bank and the passbook and 6 numbers of check with his signature and kept the same in his custody illegally, and also used to withdraw money from his Punjab National Bank account using the ATM card. And despite request, they have not been returning the aforesaid ATM card to him. And they are also harassing many poor people like him for their illegal gain. Mr. Sotia, learned counsel for the applicant, submits that the applicant was granted the privilege of interim periods bail by the order dated 6/3/2024, and thereafter he had appeared before the IO and cooperating with the investigating agents. And therefore it is contended to make the interim order dated absolute in the dated 6/3/2024 absolute in the same terms and conditions. On the other hand, Mr. P.S. Locker, learned additional PP, submits that in the case diary, there is no indication that the applicant had appeared before the IO, but Mr. Locker fairly submits that the materials collected so far in the case diary are inadequate to show any legally prosecutable culpability of the applicant. Having heard the submission of learned advocates of both sides, I have carefully gone through the petition and the documents plus on record and also perused the case diary with the assistance of Mr. Locker, learned additional PP. In view of the materials collected so far in the case diary, and also in view of the submission of learned advocates of both the parties, custodial interrogation of the applicant seems to be not warranted here in this case, and therefore the interim order dated 6/3/2024 is hereby made absolute in the same terms and conditions. Case diary be returned.
Second six.
My lord, in this case, my lord, I have found, my lord, section 4 of Probation Act, my lord, the Probation Act may be applicable, my lord. I have found some Supreme Court judgment, my lord, and after going through this judgment, my lord, Supreme Court held it, my lord, since in section 4 of the Probation Act, there is a non-obstantry clause. So, my lord, it may include any case subject to which is not, my lord, punished under life imprisonment or death. Then
Life
oth-
imprisonment
or death, my lord.
or death.
Yes.
What is
But
the
in other
punishment
case-
prescribed for 307 IPC?
My lord, this 307, I am convicted in 307.
30?
7. Okay.
Yes. What is the punishment?
My lord, this is punishment. So, my lord, if injury, my lord, then it may, my lord, life or death.
So you have assaulted your wife over her head by means of an axe.
But my lord, trial court convicted me.
Head,
Neck also.
neck also.
My lord, trial court convicted me, imprisonment of
307.
307, 5 years. So I am on that, man. Had it been convicted, my lord, life or it will be different. And my lord, Probation Act itself says, my lord, National Penal Section 4.
Heart is closed.
My lord, Section 4 itself says, my lord.
So you show me the judgments of Supreme Court.
Yes, my lord. My lord, it's a reportable judgment, my lord. In this case, my lord, initially, my lord, charge sheeted under section 307, but finally 397, 7 years convicted, man.
397 or 307 is not notice.
No, it was earlier there, but the
Conviction
law is discussing this case madam, regarding the probation act,
Hmm?
whether court has power.
No, is it related to the offense under section 307?
My lord, it was registered, charge sheeted under section 307, my lord,
No,
subsequently,
the ruling you have cited here.
yes, ma'am. But
It
punishment was
relates to
given,
307.
punishment was given, my lord, 397,
See?
97,
Hmm.
where minimum punishment is, my lord, 7 years,
Above 7 years.
every 7.
97 is
No, maybe Supreme Court has the power. Under section, no, under article 141.
No, my lord, last time may kindly see section 4 of the Probation of Offender Acts 1958. May I read, my lord?
Hmm.
Power of court to release certain offenders on probation of good conduct. When any person is found guilty of having committed an offense not punishable with death or imprisonment for life, and the court by which the person is found guilty of opinion death, having regard to the circumstances of the case, including the nature of the offense and the character of the offender, it is expedient to release him on probation of good conduct, then notwithstanding anything contained in any other law for the time being in force, the court may,
No, that is
Instead of-
there, Mr. Uddin. This section is there.
I agree with you.
so my lord, it is the discretion,
Then,
discretion of the court, man. As per the judgment I relied on for your lordship.
that's all right, but it is stated that having regard to the circumstances of the case, including the nature of the offense and the character
Yes,
of the offender. What is
So
your
I have taken
character?
the plea
You had
before the
the
trial court.
incident of criminal activities in past. You have assaulted her and she has lost one case against you. But subsequently,
But this is-
the case was compromised.
My lord, relation between husband and wife, man.
Maybe
That was the
that
case.
cannot be the excuse in all the cases.
There was no conviction in this earlier case. man.
Maybe,
There is,
but there was a case against you.
that was subsequently withdrawn, man.
Hmm.
Not registered or no,
It proves his conduct loss.
Huh?
It proves his conduct loss. This is earlier conduct loss,
Hmm.
earlier behavior loss.
So my lord, this court has.
By your conduct, you have disqualified yourselves from getting the benefit.
My lord, trial court has not given any reason, man. Only just say that I am not inclined to that.
Hmm.
In the order itself, man.
Hmm.
But my lord.
Trial court had given the reason.
Nothing, my lord, only one sentence, my lord.
Uh,
Like, for this. My lord, page 25,
hmm.
considering the fact and circumstance of the case
Hmm.
and manner in which the accused committed the offense,
Ah.
I am not inclined to give him the benefit of the
Is
probation
it,
of
is it
offender.
not the ground? Is it not the ground?
My lord, but my lord,
Hmm?
since it is convicted only 5 years, my lord. And lordship has also power, my lord.
No,
Other-
we have to examine the ground assigned by the learned trial court.
Lordship.
And
But so far, injury, my lord.
your conduct, your antecedent, nature and gravity of the offense,
But my
and the
lord,
place which the injuries were caused.
injury is not specific, my lord.
Hmm?
And
But,
my lord, the
it is
weapons which was
Over
used,
her head and neck.
my lord, the weapons which was, my lord, seized after 4 days, my lord.
After?
4 days. and also not sent for the
Have
forest.
you, maybe, but have you denied that the said weapon of offense was not used by you in your statement under section 313 CRPC?
313, I deny all the allegation, my lord.
Hmm.
And doctor also said that, my lord, this injury may be by falling also.
Hmm. But have you put any such suggestion to the victim that you sustain injury by falling in her cross-examination?
No.
First part. My lord, cross part, my lord. Near my house, there are other houses, but I do not know the names of all my neighbors. I do not know whether any neighbor people came to our home or not at the time of the incident. At the time of happening of the incident, no other family members were present in our home. I do not know the age of the elder daughter. I do not know the exact distance between my maternal home and the house of the accused person. Next, my lord. I regained my sense at home after 2 days of the occurrence. I do not know who took me and to which hospital after the incident. After 3 days of the incident, police recorded my statement. I do not know the case number of the earlier case. It has been given by me against the accused. It is not a fact that on the day of occurrence, an altercation did not take place between me and my husband for some household matters, and that the accused person husband did not attack me with an axe on my head. So there she is denying, my lord.
Hmm?
Suggestion is there, my
Hmm. What is?
this is, my lord.
Hmm.
It is not a fact that on the day of the occurrence an altercation did not take place between me and my husband for some household matters, and that the accused person husband did not attack me with an axe on my head, shoulder, forehead, and backside of my head. It is not a fact that I have deposed falsely to. So last question is
No,
there.
no. Did
How
you
injury
put any suggestion that you got the injuries by falling on hard
No,
substance?
that part is not.
Not there. Then, and the suggestion you put to her, she denied it flatly.
No, sure.
So, what is the value of negative suggestion?
That is not there. Only doctor's evidence, my lord, that suggestion was there. Well, so
So,
far, my
how
lord,
the where is the illegality committed by the learned court below?
my lord, in the statement
Hmm.
of the victim as well as other witnesses, my lord, witnesses,
No,
My-
her son or
Her
daughter
son-
is the eyewitness to the occurrence.
yes, son and daughters.
Then
There is a contradiction between the,
maybe minor contradiction may be here and there, but is there any contradiction that the injury was not caused by her father, by their father, to their mother?
no.
Then
Only-
minor contradiction may be here and there.
Yes. My lord, so far conviction,
What
my
to
lord, 507, my lord, many courts, my lord, considered,
Pardon?
in the 307,
Hmm.
my lord, some court has convicted 3 years and some has 1 year and 5 years,
Hmm.
my lord.
So what is the punishment? Is there any minimum punishment?
No, my lord. No minimum. Which is description of a term which may be extended to 10 years.
Hmm. So had it been the first offense, then we could have considered your pair.
My lord, as per record, my lord, it subject to lordship correction, my lord. First.
Hmm?
No other case is there, my lord.
No, one case was, police case was lost against you.
My lord, that was withdrawn, my lord, in our evidence also.
Withdrawn may be a different matter, but there was a case.
It is, my lord,
Huh?
regarding 498, my lord.
Yes.
So it may happen, my lord, some of husband and wife relation, my.
Hmm? This may happen, that may happen. You have the right to assault your wife. So these are.
Very good.
So, my lord, I pray some leniency, my lord. Otherwise.
Okay, we will start dictating the judgment.
Lordship.
But we will not complete it tomorrow, today.
Lordship.
Because there is one reference.
Lordship. So, my lord,
Heard Mr. Ziuddin, learned counsel for the appellant. Then Mr. P.S. Locker, learned additional PP for the state respondent number 1. And Mr.
H.A. Ahmed.
S.K. S.K. Ahmed, learned.
A Ahmed.
S.K. Ahmed, learned counsel for the respondent number 2, which in bracket informant. This appeal, in this appeal, under section 374 within bracket 2 of the Code of Criminal Procedure, the appellant, namely Mohammad Suresh Uddin, alias Saresh Uddin, has challenged the correctness or otherwise of the judgment and order dated 29/9/2023 passed by the learned Session Judge Bozali Patsela in session case number 18 of 2020, arising out of Patasar Kusi PS case number 513 of 2020. Full stop. It is to be noted here that by the impugned judgment and order dated so and so, the learned Session Judge Borpeta, Session Judge Bozali Patsela has convicted the appellant under section 307 IPC and sentenced him to undergo rigorous imprisonment for a period of 5 years and also to pay a fine of rupees 5,000. In default to suffer rigorous imprisonment for 3 months. The background facts leading to filing of the present appeal is enumerated herein below. Where is the FIR?
FIR Lordship. Page, my lord, vernacular is page 34. And we have typed it, my lord. Page 32 onwards.
Who is Ghaffur Ali, the respondent number 2,
Father of the victim.
father of the
Victim,
victim?
yes. And PW 2. Page 39, PW 2. Is the informant.
Sinoti Malika Begum. From the wife of, no, daughter of the informant Mohammad Ghaffur Ali. Law for learned additional PP for the state respondent number 1, and Mr. A.C. Ali, learned counsel for the respondent number 2. Heard in part, this is the matter on
On 18 July.
18.
All right.